This is a Cloudy Harbor 10 or less video. It's intended to inform you about the issues related to online privacy and provide background on what Cloudy Harbor is doing to address them. Videos in this series will be dense and compact, delivering their information in no more than 10 minutes. Ready? Go. The topic of this video is how the U.S. government is allowed to invade your online privacy. The purpose is to explain how the United States government is legally allowed to search and seize the online information of its citizens and foreign national residents, how it can compel your online providers to give up your information in secret without the kind of warrant specified in the Fourth Amendment, and sometimes even without judicial review at all. To simplify things, we're going to walk through an email scenario because it's a familiar technology. It's been all over the news lately, and most importantly, it's just a good plain representation of the problem. So to start with, let's build a mental context by imagining you're going to initiate an email conversation over some sensitive topic. So you're sitting at your computer in your home, and you type up the first email message in a conversation, and you hit that send button. For the purposes of this example, I'm going to assume that both you and the recipient of the message use some type of email client running on a PC. A copy of the message will be stored on your PC, and another one will be transmitted to your outgoing email server, usually hosted by your provider. In our example, that provider can be Gmail or Yahoo or Microsoft or even your own ISP. Any third party will do. At this point, you have caused a copy of your email message to be transferred from your computer in your home out to another computer owned by a third party. If the addressee for this email does not also have an account with the same company you do, your email server will forward the message on until eventually it'll end up in the server they use. Their server, the server owned by their provider, places the copy of the message in their inbox and waits for them to finish the transfer with their own email client running their send-receive process. One important thing to take away from this walkthrough is that a copy of the message will be stored in up to 4 places by the time the recipient gets it: the sender's computer, the sender's outgoing server, the receiver's inbox, and the receiver's PC once the transfer finishes. Usually, the email servers wait for the clients to tell them to delete the intermediate message copies, and usually the clients defer doing this for days, weeks, months, and sometimes indefinitely. The point is that for a time, very likely more than days, and maybe much longer than that, a copy of this email exists in 4 places, 2 of which are not in the custody of one of the named participants in the transfer. So now let's talk about the law. In the late 1960s, and well before many were thinking about the possibility and the implications of something like the internet, the United States Supreme Court created a doctrine that's really the linchpin of this whole online privacy issue today. The third-party doctrine says that when you knowingly disclose information to a third party, you no longer enjoy any reasonable expectation of privacy for that information. One conceptual result of this and the other related rulings are that there are some conditions under which you can keep information private and some conditions where you cannot. A distinction to remember here is that when you do not have a reasonable expectation of privacy, the Fourth Amendment protections do not apply. This itself may not seem that devastating. However, the court later ruled that because email messages are stored or persisted in servers in the custody of third-party providers, those messages are considered disclosed to those third parties, even though they're not addressees. This means privacy with respect to emails in servers hosted by third parties is not protected by the Constitution, and it would be up to Congress to protect or not protect through legislation. And as we've all been hearing about so much since the late spring and early summer of 2013, Congress has done just the opposite. So in our example, the message copies on the original and the recipient's computers would generally be covered under the Fourth Amendment because they're in the user's homes, a place where you usually enjoy a reasonable expectation of privacy. To obtain access to either of these places, government would have to get a search warrant based on probable cause before they could compel a look or confiscation. But the servers in the middle are a very different story. Since the court's rulings on email disclosure and the third-party doctrine gave them the constitutional opening they needed, Congress has passed laws like the Patriot Act that authorize agencies like the Department of Justice and NSA to compel third-party service providers to turn over not only transactional information, or information like when you sent a message and to whom you sent it, but even content itself covering any online data stored by a third-party provider. The Patriot Act in particular gives agencies like the FBI the power to compel your providers in secret, and sometimes with only a thing they call the National Security Letter that can be generated by the FBI officials themselves without any judicial review. Providers are legally obligated to comply and are absolved from the legal jeopardy of breaking contractual agreements or even federal, state, and local statutes that may have been broken by the act of compliance itself. We've been hearing about these requests a lot lately, both about the targets of specific investigations and sometimes for even large groups of people under no particular suspicion at all. The Cloudy Harbor remedy will protect user privacy through a mechanism we call the Secure Data Exchange, or SDE. This is a web service infrastructure that applications are built on, offering specific exchange features that avoid the privacy problems exposed by conventional web architecture and the application of the third-party doctrine. Features include things like that the exchange content is all transient. We never take custody of the content. We never store or disclose the content to anyone who is not an addressee, and this is how we deal with the third-party doctrine. Access to the system is fully anonymous. The clients use IDs that have no tieback whatsoever to human beings, and this is how we deal with the transactional requests. Anyone who obtains transactional information from us will have a hard time making use of it because they won't know who to connect it to. And finally, we will deploy end-to-end encryption, which is a highly desired feature, but as we found out from LavaBit and Silent Circle, not sufficient to actually enjoy privacy at the level that we intend. The first application that Cloudy Harbor is going to build on top of the SDE is an email client. We're going to build it so that it takes all the advantages of the SDE to protect the data being exchanged. And it's going to run on all of the popular platforms and devices that users have come to expect. Also, it'll operate in a way very familiar to legacy email users. It is not our intention to change how you use email, but it is our intention to change how it's protected. And finally, we will build in interoperability with legacy email, recognizing that not everybody's going to be on SDE right away, and you're going to have to communicate with people outside of that circle. But there is one thing to remember, that legacy email is less secure than the SDE, so any exchanges that happen there will not enjoy the same protections. So as a recap, just how is the U.S. government allowed to invade our online privacy? Well, they're not, actually, because there is no such thing as online privacy, at least not before Cloudy Harbor. I really want to thank you for your time today and encourage you to visit www.cloudyharbor.com to learn more. Also, follow us on Twitter at Cloudy Harbor, and we have a presence on LinkedIn and Facebook. Thanks again for your time.